Chapter 4 deals with confidentiality and attorney-client privilege and work product privilege. So we're going to begin this section talking about confidentiality, which is the easier of the concepts to understand. There is a tendency for people to use the terms confidentiality and privilege interchangeably. They do not mean the same thing. So you want to make sure that if you are in the habit of using the terms interchangeably, or if you think they mean the same thing, you want to make sure that you understand the difference between them. So first, the biggest difference is that confidentiality is our ethical obligation. We are ethically obligated to protect our client's confidentiality. It is extremely broad. It basically covers everything. So if you are ever asked, for instance, on a test, is something covered by confidentiality? The answer is almost always yes. I cannot even think of a time where the answer would be no. Privilege is much more narrow and specific, and so it does not cover as much as confidentiality. So let's look into the confidentiality a little bit more detail. So we have an obligation to protect anything we know about our client, regardless of the source of that information, regardless of who else might know that information. It is confidential to us. So it could be an article in the newspaper, and someone could ask us a question about our client's case. We would still have to say, I cannot answer that question. I have to protect my client's confidentiality, even though that same information may be published in a newspaper or on a website or in the news. As far as we're concerned, anything we know about our client's case, regardless of the source, regardless of the timing, is protected by confidentiality. Now, we can release information as appropriate within the course of representing that client. That is generally how we represent a client. So we don't have to go back to the client every single time we want to release information, as long as it is appropriate to the representation. We can also release information if a client expressly or implicitly consents, which we will talk about that a little bit later. So first, let's look at the ethical rule that deals with confidentiality. This is Pennsylvania Rule of Professional Conduct 1.6. Okay, so the first thing listed there, the fact that the lawyer shall not reveal any information relating to the representation of a client unless the client gives informed consent, except for those disclosures that are impliedly authorized in order to carry out the representation. So that's basically what I have just talked about, the fact that if it is necessary in order to represent the client, then we can release the information. Beyond that, we need the client's consent, either express or implied. And always keep in mind that the reason that protecting clients' confidentiality is so important is because that allows us to have a very honest relationship with our client. It allows us to demonstrate our loyalty to the client. It allows the client to trust us when they give us information. It also protects the integrity of the attorney-client relationship. So this goes to the cornerstone or the core of the relationship we have with our client. So Rule 1.6, Section B there. We do, as attorneys, being members of the bar, we do have an obligation also to use candor towards the tribunal, which is Rule 3.3. Now, what that means is that the lawyer cannot knowingly make a false statement of material fact or fail to correct a false statement of material fact that they previously made to the court. So if we are asked a specific question by a judge, or if we are offering certain evidence to the court, we cannot intentionally or unintentionally mislead the court. If it's an unintentional misleading of the court, then we would have to go back and make that particular correction. Okay. Attorney also cannot fail to disclose to the court any legal authority that's known to the lawyer to be directly adverse to the position of our client and not disclosed by opposing counsel. Now, this probably does not come up very often, but what that means is if we're in court in front of the judge and we know there's a statute, a rule, a case that hurts our client's case, but the other side fails to bring it up, we have to disclose it to the court. That if as long as it is controlling legal authority. Now, in 99.9% of the cases, the other side is going to be aware of this law as well. So we really are not going to be put in a situation where we have to basically tell negative information about our own case. But should that occur, should the other side fail their client and not find this authority that helps them and hurts us, we would be under an obligation to notify the court. Now, again, usually how this is all going to come up is going to be when we file a trial brief with the court, when we file an appellate brief. We know the law out there that hurts us and helps the other side. So we're already going to talk about it. We're going to try to show the court why they should not apply it to our case, why they should give it minimal weight. So we're already dealing with it in that way, and that's usually how it's going to be disclosed to the court. It would be pretty unusual to have a situation where we're actually standing in front of a judge and this issue come up, but it does show that we cannot basically hide the law. Even if the other side has failed to do their job, we cannot hide the law. And the third way the attorney has to show candor towards the tribunal is that the attorney cannot offer evidence that we know to be false. Now, usually the attorney is not going to do that, but what may likely happen for this to become an issue is we have a witness that ends up answering questions in a way we are not anticipating and we know it to be false. The attorney cannot just let that go. There is a question then, what should the attorney do if that does happen? Usually we catch these issues before we ever get into court through our trial prep, our witness prep, our client prep. And if it looks like you have a client or a witness that's starting to change their answers because they think it's more favorable towards their case, we talk to our client at that point. If you are ever doing that kind of prep and you see that happening, you need to talk to the attorney, and the attorney needs to talk to the client or the witness about that. So usually if there's any of those issues, we're going to catch them. We obviously always advise our client and witnesses to tell the truth. But if we're in court and something is offered that we know to be false, the attorney has to take appropriate action. There are attorneys who will say the only thing they can do at that point is ask to withdraw from the case, because you're walking a very tricky line at this point. You have a situation where you know your client or witness has offered false evidence, but you can't necessarily tell the court it's false evidence because that's also breaching confidentiality, which you still have to protect your client's confidentiality. So there is a school of thought that says the only thing you can do is ask the court for permission to withdraw at that moment, which is kind of a red flag that something has gone horribly awry, but you would at least still be protecting your client's confidentiality. So again, this is unlikely to occur, but it does show that the attorney does have an obligation to the court as a member of the bar and an officer of the court should any of these situations arise. So even though we do have the obligation to protect confidentiality, that does not mean we can intentionally mislead the court. We can hide relevant law or fail to notify the court of relevant law. Okay. So getting back to the rule, and again, this is Rule 1.6, if a lawyer represents a client in a proceeding in front of a court and knows that the person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct, the attorney shall take reasonable remedial measures to disclose that to the tribunal. So that is why the trial is actually going on. If the attorney is aware of that kind of conduct, they have to take reasonable remedial measures, which might include disclosing it to the tribunal. It may not be necessary to do that if it's something the attorney can otherwise fix. Okay. And then Part D that's listed there, if it's an ex parte proceeding, which is usually going to be an attorney going in for a temporary restraining order or something along those lines, the lawyer is under an obligation to notify the judge of all material facts at that time. Even though it's ex parte, it doesn't mean that we can just tell the facts that favor our client and leave other information out. We still have to give all appropriate, relevant information to the court at that time. Okay. The next part of Rule 1.6 deals with the situations where an attorney may be able to reveal information. Now, this list here, it is not a requirement that the attorney reveal this information. It's up to the attorney's discretion. They may reveal it. If the lawyer believes it's necessary to reveal information to prevent reasonably certain death or substantially bodily harm, or if it is a criminal act that's going to result in substantial injury to the financial interest or property. So you're talking about substantial bodily harm, that someone's at the risk of substantial bodily harm or at risk of substantial financial or property injury. The attorney may reveal that information to the appropriate authorities to try to prevent that from happening. The attorney also may reveal necessary information to prevent, mitigate, or rectify consequences of a client's previous criminal or fraudulent act in which the lawyer's services are being used or had been used. So this would be a situation where the attorney gave the client some information and the client then used that information to circumvent the law or in ways that the attorney had not intended, and somebody was harmed somehow by it. Then the attorney can take action to try to rectify that situation. The fourth one is probably the one that's the most common out of all of these, because it's not that often where we have clients who are wreaking that kind of havoc where we might feel we need to step in. But the fourth one is the one that might actually happen, and that's if there is a controversy between the lawyer and the client, such as a disciplinary complaint has been filed, a legal malpractice action has been filed, the attorney's going after the client for payment of attorney fees. Information may be shared as appropriate for the attorney to present their claim or defense. All of that would be considered an implicit waiver on behalf of the client, that the attorney can release that information. It does not mean that the attorney can just release all the information, but only the information necessary to either pursue their claim or present a defense in those types of cases. An attorney can also contact another attorney for legal advice about what they need to do to comply with these rules. So that is allowed, and actually that information is protected twice. It's protected by the first client, but it's by the first attorney, but it's also protected by the attorney's relationship with their attorney. There are lawyers who do specialize in ethical issues, and so if an attorney had a dilemma and wanted to seek out counsel, they could provide information necessary to discuss the dilemma they are having. Again, doesn't mean that they can release all information, but they can certainly release information necessary. And the last one is the sale of a law practice. There's all sorts of rules that apply to situations where an attorney is retiring or selling their practice, which we don't have to worry about for this class. And ethical rule of confidentiality, our obligation to protect confidentiality continues in perpetuity. It continues after the client-lawyer relationship has terminated. So just because a case is over does not mean that our obligation has in fact ended. It does in fact continue. And the last thing I want to mention is Rule 1.18, which is not in the PowerPoint, but Rule 1.18. This rule clarifies that this duty to protect confidentiality extends to prospective clients as well. So even if a attorney meets with a prospective client, but then the client ends up not hiring the attorney, or the attorney decides not to take the case, all the information shared is still protected by confidentiality. So confidentiality will extend from that very initial consultation between attorney and client all the way until both of them basically die. It exists in perpetuity. So it is an all-encompassing umbrella rule, and it covers everything we know. Again, it does not matter how we know about it. It does not matter who else knows about it. It does not matter when we found out about it. If it's relevant to our client's case, we are under an ethical obligation to protect confidentiality.